Mr. Chairman, these are a series of bills which concern Article 5 applications to the Congress to call a convention of states. S-133, as introduced, is a joint resolution which would make an application to impose fiscal restraints, limit federal power and jurisdiction, and have term limits. Included in S-133 are instructions to Congress about Congress performing only ministerial duties. There's also a very detailed description in S-133 about how delegates or commissioners are selected and how that they may be recalled, and also instructions to the delegates prior to the convention about what their duties are in the convention and what happens if they exceed their duties. H 3205 is very similar to S-133 in that it also is a joint resolution to impose fiscal restraints, limit federal power and jurisdiction, and have term limits. It has some also talk about Congress ministerial duties. It specifically limits its application for a period of 10 years. And in talking about delegates to a constitutional convention, it asks that when determining commissioners, delegates, that the electing body take into account race, gender, and age so as to represent to the greatest extent possible all segments of the population of the state. S-141 is a concurrent resolution, and it deals with a balanced budget. It is a single application request for a balanced budget convention of states. S-887 is a general bill. It would add statutory requirements that provide for an oath of office for anyone serving as a commissioner or an alternate to a convention of states, and it would provide that a commissioner or an alternate who is convicted of violating the oath is guilty of a felony and upon conviction could be imprisoned for up to 10 years. Mr. Chairman, as reported out of subcommittee, S-133 and H-3205 were both amended with strike-all amendments to insert the model language that is recommended by the Convention of States organization without additional language that was in either of those joint resolutions. S-141 was reported out of the subcommittee without an amendment, and S-887, the general bill, was reported out with a clarifying amendment that if an Article 5 convention is called, the General Assembly would determine how the commissioners and alternates were selected. Mr. Chairman, the amendments that were passed out of subcommittee were passed on a 3-2 vote by the members of the subcommittee.
All right. And Paula's description, you want to add anything to that, or?
Well, Paula, Ms. Benson was very precise, as she always is, and gave an accurate description. I would say that the adoption of the Convention of States language is an effort to have similar language that other states have so that a court or Congress could not consider it a separate and new and independent application and start the count all over again, because you have to have 34 states under Article 5 to call a convention of states. You have to have 38 states. You have to have 75% of the states ratify a Article 5 proposed amendment. So that's a safeguard, a very important safeguard from a convention being a runaway convention or producing a result that does not have broad support among the states. And so that's why we adopted that amendment, and with S-133, and then amending H 3205 with the same language, it's really a procedural effort to have two vehicles, one a Senate bill and one a House bill. The House bill is further along, so that would be the vehicle that we would use.
All right, so discussion about that now. Senator Harpootlian has asked to be recognized with a question.
Senator Campson, and I've done a little research on this, but as I understand it, once you send these folks to a convention, you can't really, you can't restrain them from what they're going to do. They, for instance, could repeal the Second Amendment if they wanted to. Am I correct on that?
No, there are some allegations to that effect, but if you really look at the history of ratifying conventions, like the senator from Edgefield several years ago sent me a book during the off season while we were out of session. I read the Ratification, which is Pauline Myers' account of the ratifying conventions in each state. And when you understand that state by state, and you get an idea of what conventions were, and the framers understood them to be a ad hoc meeting in order to address a single issue within parameters and to adjourn. And that's the way the U.S. Constitution was ratified throughout the nation. And there is a safeguard too, Senator, because actually I was previously against this concept, and I studied myself to position to be for it. And if you read this book, you might do the same, Senator. It's light reading. It's like 833 pages, but
long plane ride back.
What, and,
yeah,
and what,
but it's a long
what's the
plane
name, what's
ride
the name
back,
of that book,
right?
Senator?
Senator, go ahead.
I'm in Slovenia, as you know. I couldn't see the
You know
cover of
that.
that book. Could you tell me what it is, please?
Far from Unworkable by Timothy Drake, which is an account of the convention, the framers' ideas, and actually original writings and manuscripts and comments upon the convention. But the book that I mentioned that you may want to read while you're overseas is a very intriguing book, and it's Ratification by Pauline Myer. It's a very, very interesting book about the state
So-
conventions that ratified the U.S. Constitution.
So, well, let me ask you this though: could we not pass? And I mean, does it have to originate at a convention, or can each state pass a specific provision? Here, I notice one of the big concerns here is a balanced budget. Could we pass something without it going through a convention?
Well, the framers gave us two ways to amend the Constitution, and in classic framer fashion, they divided that power between the federal government and the state government, like they did numerous times. You're very familiar with this, with federalism, the concept of federalism. The Elections Clause is even something that's talked about today, and they divided that power. They gave it primarily to the states, but ultimately to the federal government. And there's many instances where they divide that power and diffuse it, and this is one of them, because in Article 5, Congress can initiate an amendment to the Constitution, and the states have their own way to initiate an amendment to the Constitution. And Hamilton talks about it in Federalist 85, that we may safely rely on the disposition of the state legislatures to erect barriers against encroachments of the national authority through this process. And so really what Hamilton said was, this is an arrow the framers put in our quiver at the state level to use against federal overreach and excessive use of power, excessive spending, or various issues. And so and they gave it to the state as a means to amend the Constitution. The federal government has a means, and so there you have this division of power over the constitutional amendment process. Samuel Jones from New York at the ratifying convention, he gave another reason. The reason there are two modes for amending the Constitution, I suppose, is this. It could not be known to the framers if there was too much power given to the federal government or too little given to the federal government. They therefore prescribed a mode by which Congress might secure more power if they didn't have enough, if it was found necessary, and they prescribed a way for the states, a mode of restraining the federal government if upon trial, error, and experience it was found necessary to restrain the federal government. So they basically set this thing in motion, this Constitution, and they really, they created a way to tweak the balance of powers between the federal and the state, the national and the state governments. And so there's many instances of that as the reason given for an Article 5 convention initiated by the states, which I was originally opposed to it, but after having studied it, I really studied myself to a position to be supportive of it. Because I understood the framers' vision and reason for doing it.
Has there ever been, when was the last time we had a constitutional convention?
It was the original Constitutional Convention the last time, but
Yeah,
we came really close in we came really close in 1917 on the 17th Amendment when we were one state away from adopting that through a Convention of States process, and that precipitated Congress initiating the 17th Amendment and having it ratified. And that's the amendment that made U.S. senators elected popularly instead of by the state legislature.
So I guess my question is this. This is my major concern. We send folks to a constitutional convention. I looked. I can't find any case, there's theories, they quote Hamilton or whatever. What is to prevent them from doing more than something on a balanced budget? Could they repeal the Second Amendment? And I can't find a single source that says once they go there, they're free to do anything they want. They're prohibited from doing anything else. Is there something I've obviously read the amendment, the Constitution, but I can't find a single case, Supreme Court or otherwise, interpreting that in any way, shape, or form. Am I wrong about that?
There's no Supreme Court case about that, although there is a history of conventions sticking by the subject matter. So if you had a court presiding over a, quote, runaway convention, first of all, a convention is not going to be run away when you have a 3/4 ratification requirement. That's really the safeguard, because I'm concerned about that too. But when you have 3/4 of the states have to ratify whatever the outcome is, first you have to have 2/3 of the state delegates agree. Then you have to have 3/4 of the states agree with their product. And the chance of a runaway convention receiving that kind of support is very, very impossible, I would say.
Virtually.
Yeah,
impossible.
you'd have to have 38 states agree. You'd have to have 38 out of That's a very high number, very high threat. It had to be something that red states, blue states, east coastal states, flyover states, northern states, southern states, they'd all have to agree. It would be really big, major issues that aren't extreme, that to get 38 states to agree through their ratification of the proposed amendment. And as a state lawmaker, it is a arrow that the framers put into our quiver to use and to push back against the federal government if we think it's getting too big, spending too much money, getting out of touch.
I have long supported Article 5 convention, and one of the things that the Senator from Charleston pointed out, and I think this is important to our friend in Slovenia for us to make very clear, this is not a constitutional convention. This is an Article 5 convention under the Constitution. And I think that's one of the things that people have lost focus of. Nobody's talking about putting the entire Constitution on the chopping block. I don't think the founders intended for it to be a self-destruct button built into the Constitution itself. It was a self-correction tool. I think that they were more concerned in reading the Federalist Papers, Senator Campson, Senator from Charleston, and reading the records of the Constitutional Convention. I think the Founding Fathers are far more worried about a runaway federal government than a runaway Article 5 convention. And I feel like that's... But I think that's the point being, that's what everybody was worried about, is that the federal government get out of control, not the states. The states are far more, at least states like ours that live in a balanced budget now, we're far more restrained than Washington is. So I'm less concerned about us destroying the Constitution than Washington destroying the Constitution. And as Senator Campson pointed out, and I think this has been true in every state that's debated this, and it's certainly in the Constitution, it's not like you can just go and have a constitutional convention, as we keep hearing it referred to, rewrite the entire thing and then shove it down the state's throats. Everything proposed here still has to go through the same ratification process that you would if Congress proposed these things. So all we're saying is, we're telling Congress, we're taking the power out of your hands by doing this, and we're going to propose stuff y'all would never propose, because I've never seen Congress vote to restrain their own power or control their own budget or limit their own terms. And I think I just want to be clear that when people say we're talking about shredding the Second Amendment or rewriting the Constitution, that's not the intent. That wasn't the founders' intent. And I know the subcommittee worked really hard, Mr. Chairman, to ensure that was certainly not the intent with the state of South Carolina. So I appreciate it, Mr. Chairman.
Mr. Chairman, if I could just say one other thing. We also have in our package a bill that deals with a unfaithful delegate. If a delegate is unfaithful and does not stick to the issues that are provided for in our joint resolution, then they would be subject to criminal penalties if they're an unfaithful delegate. And I'd like to also just this is the last thing I'll read if we're ready to vote, but I do want to get this out on the record. And this is from Jimmy Carter's Justice Department, actually, 1979. It's a memorandum opinion of the Attorney General. And he was asked about, can you limit the power of proposed amendments to the Constitution in Article 5? This is what he said. This is his conclusion. We are inclined to think that the Convention Clause has been misnamed. It should have been named the Application Clause, because its basic purpose was to provide the regular governments of the states with the means of applying for amendments to the Constitution. And the convention procedure was simply a device, one of two devices considered by the framers during the evolution of the clause, through which the demands of 13 contentious states were to be reconciled. The process was a flexible one. New York and the Anti-Federalists pressed for a convention in 1788 and 1789. On the other hand, if the legislatures feared the divisiveness of a general convention, meaning a runaway convention, yet there was insubstantial agreement regarding some particular problem or issue, they could, as Hamilton suggested, generate specific proposals through the convention procedure without risking a general convention. So Hamilton believed that you could limit the convention to the issues that the applications are asking for. And in this instance, we're asking for federal restraint, term limits, and reining in federal power in one resolution, and the other is a balanced budget amendment. So I'll cite Hamilton, no greater authority probably there than he believed that it could be a restrained convention.
All right, and with that, that would be a motion?
A motion to adopt the amendment, the committee amendment
Right.
on 133.
All right, Senator Garrett seconds that. All right, any discussion on that? All those in favor say aye.
Aye.
All right, any opposition? There being
No.
none, there being a...
No.
All right,
No.
3, register, in fact, if you will, register the opposition.
Nay.
Senator Harpootlian, we hear you?
Kempson.
And Senator Kempson, okay?
Senator Stevens.
Senator McLeod, I'm sorry. All right, if you oppose this, let's see a show of hands. All right. And Senators McLeod, Senator Kempson, and Senator Harpootlian, I can't. Okay. 15-8 with that. All right, by a vote of 15-8, that motion passes. All right. Senator Kempson, the other bill.
That bill as amended, a motion to adopt the bill as amended.
All right. Second, all right. And can we, any objection to using the same vote, 15-8? Any objection to that? All right, there being none? Okay. All right.
Mr. Chairman, the next bill is
Mr. Chair, I know there was a nod to that, and I just want to just say that this bill is obviously one that has been around for a period of time, and basically we get a chance to use it on the Senate floor and be able to have a discussion on that. I've had a discussion with that with the majority leader, minority leader, and basically the bill's going to pass committee, and so the senator from Charleston, I use him as an example, that had some reservations. He's worked on the bill in a way that he's gotten it such that we can support. And so customarily in the Senate, we end up moving a bill out of committee reserving all rights. And so today the bill needs to move forward, both of them, same way reserving all rights. And so we'll end up changing some things on the floor because there'll be other amendments. This is a process. We need to end up moving it forward.
All right, Senator Kempson.
Mr. Chairman, the next bill is S-141, which is a concurrent resolution dealing with a balanced budget amendment, a resolution to propose the balanced budget amendment. Yes, it's not, the bill is reported out. It's not an amendment. I was talking about a balanced budget amendment was the subject matter of the resolution, but we reported it out without amendment, out of the subcommittee. And that's S-141, it's called for a Article 5 convention for balanced budget.
Okay. Motion made, seconded. All those in favor say aye. Any opposition? All right.
Nay. Nay.
All right. Senators Sabb, Stevens, Kempson, any other? Senator Matthews, Senator McLeod, y'all are looking, guys, please. Senator Harpootlian, see you waving. Senator McLeod. Senator Matthews, okay. All right, by whatever that vote is that Ernst & Young will tell us later, 14-7 or thereabouts, that motion passes. And if you're, any questions about your vote being recorded, check with our Ernst & Young representatives up here. All right, next.
Mr. Chairman, the next bill is S-887. This is a bill. The next bill is S-887. This is a bill dealing with a oath being required by delegates that they would be faithful to the reason that the convention is called, and if there is a violation of that oath, then they would be subject to criminal penalties. The criminal penalty is up to 10 years and a felony. We do have an amendment on the desk that clarifies that if an Article 5 convention is called, it's at that time that the General Assembly would determine how commissioners and alternates to the convention that have to take the oath are selected. And so that is an amendment that's before us now, a committee amendment.
Mr. Chairman,
Yes. Senator.
Senator, yield for a question.
Yes.
Senator, I'm just curious. So I think we're required to have an election and send delegates to vote to participate in the Constitutional Convention and discussion in the Are they elected during a regularly scheduled election, or we gonna have a special election? This is
Well,
a popular vote. It's a General Assembly vote.
The General
How do we go about?
All right, everyone, you have been watching a vote of the South Carolina Senate Judiciary Committee, which has advanced the Convention of States Action Article 5 application by a vote of 15-8. So congratulations to the South Carolina team. We were letting you watch some other Article 5 related action as well there. They're also discussing a faithful delegate amendment. So this means we're on to the South Carolina Senate. And that is a big step for the South Carolina team. So we're super proud of them. So stay tuned for future action. South Carolina looks like they have the inside track on being state number 18 to join the movement. So stay tuned to our website as well as all of our socials to be tuned to the latest information. Thanks.